Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting at a diverse location within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
All right, good afternoon, everybody.
Good afternoon.
Afternoon, Judge.
This is Judge Englander. We're here on a hearing with respect to an order on a motion to waive the appeal bond in connection with a summary process case out of the Housing Court in Central Division. I don't know the number offhand of this in our court, but the caption is Julian Zacarias against versus Katie Airasian.
Yes, sir.
Correct. All right. So, Ms. Airasian, I've read a lot of the papers. I can't say I have consumed every one of them, but I think I understand what's going on. I may have some questions. The law with respect to this appeal from the decision on your motion to waive the appeal bond is that I'm supposed to review the decision of the lower court, and that what you needed to show in order to have the appeal bond waived was that you were indigent and that you had non-frivolous defenses to the summary process claims that were brought against you. And so that's what I don't know that there's any challenge to your indigency. Mr. Cortese, are you challenging indigency?
We are not, Your Honor.
Okay. And you're counsel for Mr. Zacarias, is that right?
That's correct, Your Honor.
And were you counsel at trial as well, sir?
I was, Your Honor.
Okay. So Ms. Airasian, what do you want to tell me? And you shouldn't be nervous. I know you probably are, but I'm here to try and understand what your arguments are.
Okay. Your Honor, what I would like to speak about in this hearing is why I asked for this appeal, what I would like the court to do, that I qualify for a waiver of an appeal bond as I am indigent and I have serious legal reasons for an appeal. And then lastly, inconsistency with the plaintiff's opposition. Why I asked for the appeal, Housing Court Judge Horan did not carefully review the docket of the case and the relevant filing before making a ruling. Specifically, she negligently did not even know that I filed a motion to waive the appeal bond on 11/16/2020. I know this to be a fact because, as I have stated in my motion to the court, in Judge Horan's order of 12/7/2020, she gave a history of case filing events leading up to her order and never mentioned my motion to waive the appeal bond. And she stated in her order, the defendant did not ask that the bond be waived prior to the hearing. That is factually false. I filed a motion on 11/16/2020 asking to waive the bond. Judge Horan did not carefully review the docket of the case and the relevant filing before imposing an appeal bond on me. What I would
So
like
the motion to waive the appeal bond that you filed, I think I've read. It's dated 11/6/2020. It is in the file.
11/16, correct.
Well, okay, it's dated 11/6. It's stamped in. Okay, it's 11/16. You're right.
Okay, sorry.
And the judge's order was entered on December 7th. And what you're saying is you don't think that she reviewed this. What is there in this motion to waive the appeal bond that you were heard orally by Judge Horan, though, right? She heard.
She noticed that I orally asked for it, but she said in her findings that I did not ask for it prior to.
Right. But that's not necessarily important unless she missed some point.
But she told
that you think is critical and that would entitle you to some kind of waiver. And in order to be entitled to a waiver, you need to show that you have non-frivolous defenses to the summary process action. Let me ask you a few questions.
Sure.
Is it true that you have paid no rent at all for almost 24 months?
Yes, sir.
Okay. And what defense do you have that has not already been addressed by the court at trial to why that is acceptable under the circumstances? And if what you want to tell me is the court at trial committed clear error, then I'll listen to that too. But
Yes,
why?
sir.
Okay.
I have.
Why
I
is it
have my
that
le-
why is it? Let me put it this way. So, why is it that the judge was wrong in ordering possession and ordering you to pay $13,000 under circumstances where you have not paid any rent since, where there's a finding and you admit you have not paid any rent since at least January of 2019?
My defense against the original claim is that my rent was paid in full. No notice to quit or summary process complaint should have been allowed.
Okay.
I
and
had receipts.
The judge rejected that as a matter of fact. He had a trial hearing. He had you testify. He had Mr. Zacarias testify, and he found as a matter of fact that you had
Okay.
not paid.
So I have three main reasons for the appeal. Is that what you're looking for, sir?
Well, I need to understand what the non-frivolous defenses are, and
Okay.
I'll go through whatever it is that you want me to, but I'm going to ask questions because I need to understand the arguments. I'm not simply going to listen.
The judge made errors, sir. So first, separate and unequal requirements for parties by the court for trial. The housing court issued 5 different orders requiring parties to submit pre-trial memorandums, but failed to enforce any of them against the plaintiff.
I read a lot of these. If these are procedural arguments, how do they overcome the fact that you haven't made any payments? There's a finding that you haven't made any payments.
Specifically with the requirements that the witness to be called in the trial be listed and to provide a summary of expected testimony for each witness. The plaintiff never listed him and the witness along with the expected testimony. As the trial Judge Kane, despite my objection, allowed the plaintiff to testify beyond what was the notice to quit and complain. I had no way to prepare for much of the testimony, completely unfair.
So what is it that the plaintiff said that you weren't prepared for him to say that you think had an impact on the trial?
He talked about the receipts. He talked about prior things that were not a fight that broke out, things that were never brought up prior to, and I had no idea he was going to bring up, so I had no defense for it.
And what defense would you have provided? What is it that he said that you think harmed you? And what would you have been able to respond to had you had prior notice?
I would have evidence, payment of rent, other than my receipts.
Well, you knew that the allegation was you hadn't paid your rent. I mean,
yes, and I had receipts to that. But like I also said, that the judge used copies of instead of the originals, which I believe made his decision not, because he clearly, Judge Kane erred in not using the evidence available to him. He had original copies, but he instead used the imperfect copies with my receipts. And then he said in his findings that he would have used my bank records, but prior to that, I was not allowed to use the bank records. That's what the trial and I brought it up in court to the Judge Kane, and he never gave an order on it. So when I
on
did
that
the
one, again, on that one, you made that argument in your motion for new trial. You made it as well as you could. The judge rejected it squarely, finding that he did not, based on what you had testified to at trial, he did not find it credible that it was the clerk who told you not to put the evidence in. Right?
He used his notes and not my transcript of the trial.
So where the judge quoted, and I thought he quoted to a particular time in the oral transcript.
He
You're
used
saying that was
notes,
wrong?
not the transcript.
He says she testified as follows. And then he quotes you. And then in his footnote, he says the excerpt quoted can be found beginning at approximately 10:58 a.m. on the FTR recording of the trial. He wasn't going off his notes. He was giving a direct quote from the trial recording.
I haven't seen it. I believe that was from his notes.
Well, that's not what he says. I don't know how I could find that to be incorrect, where it's literally what he says he did. And he gives, I can go back maybe, in order for you to win this argument, you would have had to provide me with the recording at this point and indicate why he's wrong.
Can I get an appeal bond to waive to get the fee to get the?
No, ma'am, this is what you needed to do before you came into court for this hearing. Instead of representing to me, he did it from his notes, where his own findings are that it was from 10:58 on the actual recording. You should have been aware of that beforehand. And if you think he was wrong and it actually prejudiced you, you needed to bring that to my attention before.
Sir, I'm like I said, I'm indigent and I can't afford that. So
I understand,
and
but
plus I'm not a lawyer, so I did not know that. I'm going on the knowledge that I'm getting from help, and so.
Ma'am, I understand that, but and I will give you time to make your arguments. But if you come to me and you make an argument that is demonstrably wrong on the record before me, I'm going to point that out to you. And the judge pointed it out to you in the same order. He said, you made an argument that it was the clerk who told you this. And he pointed out to you, that isn't what you testified to at trial. And those are things that we as courts have to pay attention to. Okay, so why don't you move on to what other non-frivolous defenses you have?
The receipts, he said, were invalid because he looked at the copies, said they didn't match. And that's a major one of my problems, because he was using a copy and not the original. So he's saying it didn't match the initials that were on the other documents, and it's because he used copies.
Okay. I actually thought he said something slightly different, but
for the months in dispute that he was talking about.
Right,
for the
but
months.
what he said, I thought, was that
if he had not looked at the copies, he would have seen the original signature, the original initials, and the initials that would match the other ones. That's on the lease.
I think what he said is that he'd asked you, or someone asked you, why didn't you obtain a signature? And his finding, again, this is a finding of fact, was that you didn't have an explanation for why you didn't obtain, rather than obtaining a signature, you only obtained the
He didn't like that it was initials. He would have preferred that it was a signature, but I told him that that's just the way we did it. I did that with the original landlord, and I also did that with this landlord. And I didn't know it would be a problem.
Am I right that So I understand this. I understand this argument. I do. But the difficulty with an appellate court is we're not allowed to disregard the findings of a lower court on findings of fact made on credibility unless it can be shown that they are clearly erroneous on the record in front of us. How could I decide that his findings are clearly erroneous on this record?
Procedure errors. Procedure error looked at the exhibits. They are copies, and that's my main problem. The exhibits were copies. Now, it was at the trial. They weren't the originals. So and that's my. I just don't understand. You know, it should have been the originals. I had the originals. I offered them, and they weren't used.
Okay. Is there anything else that you want to bring to my attention that you would raise on appeal that's a non-frivolous?
One second, Your Honor. I have one more thing. Hold on.
Oh, can I ask you, Ms. Airasian, is the landlord still living in the building?
As far as I know, yes. Yes,
Well,
he is.
It's only a 4-unit. Yeah, okay. It's only 4 units, right? Or 3 units?
Correct. My
And
last thing.
he had been
I'm
a
sorry.
tenant. He had been a tenant of the building with you for some time before July of 2018, and then he bought the building. Is that what happened?
Yes, sir. My last thing is I shouldn't be expected to pay fees I can't pay while asking for a waiver and show up with transcripts. I just don't know how I'm expected to do that. I can't afford the transcript, so how am I supposed to have those?
I'm not sure, but I think if you check with the court clerk, well, you need to check with the court clerk. It's a question that I don't know the answer to, ma'am, as to whether or not if you show indigency, the transcript can be provided without charge.
That's part of this process that I just did, isn't it? Everything that I just did.
What I don't know.
Everything is waived, or nothing is waived, correct?
I don't know the answer to your question. So you've been
That's
shown.
the form I'm just confused because that's the form I filled out, sir. The affidavit of indigency. It asked what I wanted waived. So that's why I'm confused, because I filled that out and it asked what I wanted to be waived, and that was what I put the fees of the transcripts. So I did ask for that. So
if you've asked for that, you check with the clerk in the housing court. My instinct, without knowing for sure.
Doesn't the judge need to sign off?
If I might, ma'am, you have to let me speak. You can't interrupt me. Okay.
I'm sorry.
Thank you. My instinct is that if you're indigent, the transcripts will be provided without charge, but I don't know that. It's just not something I know. The person who will know is the clerk of the housing court. You've established your indigency. It's not contested by your opponent. The only question is, does that entitle you to a free transcript? I don't know the answer. Check with the clerk of the housing court.
From my understanding, when I filled it out, it said all fees are considered for waiver as part of a waiver bond. So it's all or nothing.
I don't know. I don't know the answer to the question. I know what's in front of me, which is your request to waive a bond, which means that you want to go forward with an appeal, continue to stay there, continue not to pay any rent, which you've been doing for 2 years. And in order to do that, you have to have a non-frivolous argument on appeal. Judge Horan found that you didn't. I'm going to hear from your opponent now, and then I'm going to take the matter under advisement. What would you like to tell me, Attorney Cortese?
Thank you, Your Honor. I'll rely in large part on the opposition and the testimony given here today. I do feel an obligation to bring to the court's attention. I don't know if you've noticed it today, but I've certainly noticed there is somebody talking in the background just prior to Ms. Airasian's speech. Coupled with the very long and tortured history of this case, it would lead me to believe that she's having a discussion with someone. And I just want to put that on the record, Your Honor.
I don't know why that matters for purposes of the decision that I'm going to make. She's entitled to get whatever help she can get. She's representing herself. I heard what you said, but honestly, it will have no impact whatsoever on how I decide the case.
Okay, Your Honor, I'll move on. Given all the issues that Ms. Airasian has raised today, I believe they've all been raised before. They've been raised at trial. They've been raised at the motion for a new trial, and I think they've all been denied. Just briefly, Judge, she alleges that the notice to quit was improper. Judge, that was addressed at trial, and I believe the judge made findings on that. She addressed the fact that the receipts that she claims that were for rent were not valid. There was extensive attention paid to that during the trial, and I will tell the court that my client testified, I believe, credibly, and it appears the judge believes credibly, the trial judge appeared credibly, that those receipts were not valid. My client had testified that he had not given her any rent receipts.
When you say those receipts are invalid, you mean they were forgeries? They were fraudulent?
I would say fraudulent, Judge. Let me put it this way. My client testified that he had not given her any such receipts as she proffered because he had received no rent for those months. I don't recall what months those were. That was part of the trial, which was lengthy in and of itself. But he denied strenuously that he had given her any receipts because he had not received any rent. And
what was the evidence at trial? Was so he buys the house in July of 2018, in the middle of the month?
That was before my involvement in the case, but that's my memory, Judge, of the trial transcript, yes.
Well, you were at trial, though.
I was at trial, yes, Judge.
Yeah, okay. So she pays by money order in September, right?
Correct.
And is that the first month that she owed any rent at all to him? Or did she also owe money in August and pay it?
Judge, I'd have to go back to the transcript. My memory is not good enough to answer that question.
Okay.
I can tell you that Your Honor's recitation of 24 months with no rent is accurate by my count. That's my memory, that she had not paid any rent. I can tell you that my client...
Well, she disputes whether she paid rent in November, December, and I believe January.
That is correct, Judge.
And then after that, she chose not to pay rent.
That's
and
correct.
Her defense was that she understood the notice to quit to say that she didn't need to, and the judge addressed that by pointing out that that's, at least to his reading, not what the notice to quit says.
Yes.
So she at least hasn't paid since last February. It's almost 24 months in itself.
Correct, Judge.
All right. What else would you like to point out, counsel?
Judge, I addressed the timeliness issue in my opposition. I can look at the dates. I believe there was a period of 12 days before the issuance of the order and her appeal, Judge. I would point that out for the court just for the issue of timeliness. Having listened to her.
Wait, I don't understand. I lost you there. The issue of timeliness of what?
Of filing of the appeal. the appeal of the appeal bond.
Oh, you think the appeal's too late?
I
'Cause
do.
It wasn't within 10 days?
Correct,
Yeah,
Judge.
I don't need to address that.
All right. Thank you, Judge. I would just say that having listened to her defenses today, they are defenses that have been heard and addressed by the lower court on at least one occasion, in some cases on 2 occasions with the motion for the new trial. I don't believe that they lead to a position where the appeal bond should be waived.
Did Judge Haran have a, it's a very low standard. If the appeal bond were waived, she would still have to pay use and occupancy, right?
Correct, Judge. And that's in the order.
And that's the recent decision of the SJC on that point, right?
I have seen that, Your Honor, yes.
King case that came down a few months ago. So can't waive use and occupancy no matter what. Did she pay the January use and occupancy that's ordered?
She did not, Judge. She has not paid any money to me as directed in the order. And I will say from conversing with one of the court clerks, I want to say about 8 to 10 days ago, I don't have the exact day, she had not paid any of the use and occupancy bond into the court either, or the appeal bond.
Well, she didn't owe any use and occupancy until January, according to the court's order.
Use and
The court's order
occupancy,
says
yes.
starting January 1.
Right.
Ms. Airasian, did you pay the use and occupancy?
No, I did not.
And why is that?
Because it was for use and occupancy. It wasn't for me to stay in the apartment. So
Actually, I think you have that wrong. Listen, if I might.
I'm sorry. I asked the court to set the value of the house at $600 per month because there's conditions in the apartment that I have no heat in part of it, and that there's a large construction site going on next door. And so that's why I have not paid it yet. And the last
You were
thing is
ordered
that
to
I asked
pay it
the
on
court to
January
do-
1.
The last thing is that I asked the court to suspend an order for use and occupancy payment during the appeal of the CDC eviction moratorium. I filed for that in October for the CDC protection order. The request for use and occupancy.
That is not before me right now. There is
Okay.
nothing, I don't have.
It is on the docket because I made sure I filed it on the housing docket and in October. And I also sent a copy to my landlord, and I also sent a copy to Mr. Cortez.
Okay, well, it's not before me, and I'm not at all sure. In fact, I suspect that the CDC order cannot suspend use and occupancy payments of this type. That's what I suspect, but in any event, it's not before me. I think I've heard enough from both parties. If Ms. Airasian, if you have anything more that you want to tell me, I'll give you a few moments to talk about that. If there's something that I haven't allowed you to tell me, you should tell me now.
Well, I would like to say this is not a trivial administrative matter where I say that I had separate and unequal requirements for the party. They were asked 5 different times, the defendants the plaintiff to bring up the pretrial memorandum, and the plaintiff never did so. Specifically with requirements of the witnesses he would be calling at the trial be listed, and to provide a summary of expected testimony for each witness. That was never did that come, and it was ordered by the court, and it was never given. So when it came to the trial, it's unfair treatment that I had to do what I had to do. I filled out many documents, noted everything I was going to say, all the questions I was going to ask, so they were well prepared, whereas I was not, and that was never brought up.
I did not mean in any way to suggest that these were trivial arguments. That was not what I said. Those were procedural arguments, and what I was trying to do was get you to focus on the issue of non-payment of rent, which to me is the substantive issue. But I understand that you have arguments with respect to process as well.
Okay. Thank you, Your Honor.
Thank you both. Thank you for your time. I'm going to take it under advisement. Okay?
Okay.
Understood, Your Honor.